because I wasn't here when we got started. Unfortunately, did we do it?
No, we jumped right in.
Can we do a quickie? Can you do a quickie? No, that's okay. We'll save your voice.
Yes, that's
Okay, so today is Parent Leadership Institute's regularly scheduled session called Accountabilities and Remedies. And Parent Leadership Institute is a program that is sponsored by Gwinnett Stop through a grant provided through the Just and Fair Schools Fund. So we were charged to put on this Leadership Institute for parents to train them. It is an 8-month training program. We've covered different topics on formal training once a month. And then the parent participants, parent and community participants, do a community-based project around impacting the school-to-prison pipeline. So we are focused on restorative practices. We are focused on PBIS. We're focused on changing school climate and making it one that supports children and thereby supports our community. Today, we are joined with our organization partners, the Atlanta Community Engagement Team, David Payne, Pamela Perkins with the Interfaith Children's Movement, and ACLU of Georgia. To put on, we are working together statewide, training communities in parent advocacy, community advocacy, education advocacy, and through the tool of local school councils. So all of this is kind of foundational in you understanding the next part of the training this afternoon. So with that being said, and we'll talk a little bit more as we go through the afternoon, but I want to introduce our next speaker with the Office of the U.S. Department of Education, Office for Civil Rights, Mr. Andy Duroger, has worked for OCR as a general attorney since April 2011, and prior to that as an investigator in the enforcement of federal civil rights laws and regulations that prohibit discrimination on the basis of race, color, national origin, gender, disability, age, and the Boy Scouts of America Equal Access Act in 4 southeastern states in complex complaint and compliance investigations, resolutions and negotiations involving recipients of federal funds and public education systems. In addition, he has served as a mediator for OCR's full early complaint resolution team. Andy has received his BA from Tennessee State University, his MED from Loyola University in Chicago, and his JD from Georgetown University Law Center. Welcome, Andy.
Good morning, everyone. As you stated, my name is Andy Duroger, and I'm an attorney in OCR Atlanta. I have to apologize. I just got back from DC this morning. I was there for a week-long training, so I'm feeling a little bit sick. So I look a little out of it sometimes. I'm still there. I just look that way. I'm fine, though. What I'm here to talk to you today is I have 2 presentations. The first presentation I'm going to talk about is OCR 101. That's basically going to give you a gist in the background of what we do in OCR, how we handle complaints, how you would file a complaint with our office, and kind of just take you through that whole process. After that, we're going to take a little short break, and the second presentation I'm going to give is going to be on Title VI, and that's going to deal specifically with racial discrimination. And so we'll look at how we analyze racial discrimination, we look at racial harassment, and just different kind of examples. What you're going to hear along the way from me is a lot of examples I'll give. That's basically what we do. Because we work for the federal government, we're limited in what we can actually tell you or what information we can give about particular cases, because that would be a violation of other laws and privacy. So what I'll do is I'm going to give you, vague examples, but these will be situations I have experienced and seen in the field. Okay? And this slide just goes to exactly what I said. And if you have any questions, let's wait till the end, because a lot of times I'll probably answer your question a little bit later in the presentation. So if you have any questions, wait till the end of this presentation, and then I'll be happy to answer all your questions. Now, what is OCR? We are a federal civil rights enforcement agency. All of the bigger agencies in Washington have an OCR wing. So HHS, Health and Human Services, has an OCR wing. SSA has an OCR wing. And all these wings are devoted to dealing with discrimination, discrimination as regards to civil rights law. Now, the mission of our office is basically we're trying to ensure equal access. We're trying to make sure that all students are given the same opportunities and there's no discrimination on the basis of race, national origin, disability, sex, age, and one other issue, the Boy Scout Act of America. We have 12 regional offices. As you can see, they're all over the country. Every regional office has a number of states. We're in Atlanta, and we have Florida, Alabama, and Tennessee. Headquarters, Washington, D.C. That's where we keep our project legal as well, and they're the ones who give us all the policy guidance that comes down to the various regional offices. So this is just an idea, and we all have the same basic setup. The office will have investigators, the office will have attorneys. We'll have a chief regional attorney, which is basically our chief legal advisor who gives us the final say-so on anything that we're going to send out. Now, as I stated, we enforce several civil rights laws. Now, we're going to also look at Title VI, and I'm going to talk about that a little bit later. Title VI deals directly with discrimination on the basis of race, color, or national origin. You'll hear me mention LEP students, that's students with limited English proficiency. That is something else that falls within Title VI. Title IX deals with discrimination on the basis of sex and gender. A big issue that's coming up now is gender stereotyping, discrimination on a perceived gender trait. So, for instance, we might get a situation where someone says, you know, you're acting like a girl. Now, that kind of thing is saying that whatever your behavior is not meeting a perceived gender stereotype, and we could look at that. Now, generally, someone might say, if you're discriminating on someone because they're gay. Now, it's hazy for us because in our office, a lot of times when we get that, are they discriminating against you on your sex, or are they discriminating on you because you're acting a certain way? So when we have an acting a certain way of behavior, then we can look at it, but just saying someone's gay is usually not enough for us to go and look at it immediately, unless it's used as a slur, and I'll talk about that a little bit later as well. We also deal with disability. Section 504 of the Rehabilitation Act talks about disability, also Title II of the American with Disability Act. So these are the other laws we look at. We look at the Age Discrimination Act as well. And then at the bottom where you see we talk about patriotic youth groups, that deals directly with the Boy Scouts Act of America. In my time I've been at OCR, I've never actually had a case involving that, and not many people have, but that deals directly where you have a patriotic youth group that wants to use a public facility, so a school, a library, and they're barred from it. So they have special protections, and our office will look at that as well. Now, how do we accomplish our mission? We have a number of ways we accomplish our mission, and I'm going to go into all of these into detail. Filing complaints is the number one thing. We receive thousands of complaints over the course of a year. A complaint is just that. You have a particular parent, an advocate, maybe a student, has a problem, feels like they're being discriminated, they go and they file a complaint on our website, or they can send a complaint in. The vast majority of the work we do is individual complaints. Occasionally we also get class complaints. We might get an advocate saying an entire group of students or an entire population of students are being treated differently, and it's one of the bases that we can go into, and so that's another thing we do, class complaints. Now, compliance reviews are things that come down from Washington. In a compliance review, what's going to happen is there'll be a big systemic problem that we've noticed things have been going on for a while, and Washington will initiate for us to basically have a large-scale investigation where we might look at a particular school district. So, for instance, we've done compliance reviews in DeKalb, Gwinnett, Cobb County, where there's a huge problem that we've seen in a lot of our complaints, and we send out a number of individuals, and we go and investigate that. And so it's not an individual complaint, but we're looking at it more wide scale. In a particular complaint, you might say, my particular child was treated differently because of X, Y, Z. Whereas a compliance review, we would look and say, this entire district is treating students differently, and we would go look at all the elementary schools, all the middle schools, all the high schools, all the alternative schools. So that's kind of the difference in a compliance review and a complaint. And last, technical assistance. Technical assistance is just what we're doing right now. We come out to try to give some information for people who might have questions about what we do or a particular issue. Most of the time, our technical assistance is reactionary to a particular case. So there's been a case, something happened, and the school district might say, well, we don't really understand. Can you come out and provide technical assistance for us so we can understand what it is you want us to do and why you want us to do it? So those are the three ways that OCR goes about accomplishing its mission. Now, our jurisdiction, basically we have jurisdiction over anyone who receives federal financial assistance from the Department of Education. And you hear me use the acronym FFA, that's Federal Financial Assistance. We're going to look at state educational agencies, so the Georgia Department of Education, the Florida Department of Education, the Alabama Department of Education, things like that. We're also going to look at all elementary and secondary schools within the school system. We also look at colleges and universities. And when I say that, we look at both public and private college and universities. In some instances, there's some for-profit universities that don't receive FFA, so we would not have jurisdiction over those particular universities. And lastly, we look at state vocational rehabilitation agencies. And going back to the last slide, a lot of times you'll hear a particular employment issue. A lot of times people think that's only EEOC. We can actually look at employment issues if they fall within one of those groups I just had on that last slide. So if it's an employment issue at a school, employment issue at a college, and it's based on one of the laws that we enforce, we can look at that as well. This is just going over what I just said about having jurisdiction over certain public entities. Title II and 504 are a little bit separate. 504 gives us basically jurisdiction over all public schools and private schools. Title II gives us the jurisdiction over the actual public schools because they're private institutions, so they're not always covered under 504, but they're definitely covered under Title II. Now, Title VI of the Civil Rights Act of 1964. As I said, I'm going to give a whole presentation on that, so right now I'm just going to kind of gloss over it. And this is any discrimination on the basis of race, color, or national origin. Examples of what we look at when we have a Title VI complaint, we're going to look and see if students are being treated differently. As an attorney, a big part of our analysis is always different treatment analysis. And we're going to look at the particular student in the complaint, and we'll ideally try to find a comparator. So someone we can compare them to who are similarly situated and say, was this student treated differently? So that's basically the basis of different treatment. And it goes a little deeper, but that's just a surface level breakdown of what we'd be looking for. Also, are we assigning students to educational programs on the basis of their race? Are we, when you see sometimes we have a bunch of students and there'll be a guidance counselor, and the guidance counselor is sending all the black students to general education courses while all the white students might be going to advanced level courses. That would be something we would look at as well. Also, we're going to look at harassment. Harassment is a big issue, and it also ties in a lot of the policy we've seen on bullying. We have kind of tied harassment and bullying in together so that we can go and attack that. One big issue people have is they think that any bullying that occurs we can look at, and that's actually not the case. We can only really look at bullying again if it falls within one of those laws that we actually enforce. So in the case of someone being bullied on the basis of their race, color, national origin, then that's something we can look at as well. And lastly, under Title VI, as I stated earlier, not giving resources to students with limited English proficiency. I actually had a case in one state when I started where if a student had limited English proficiency and the parents did, they weren't actually receiving translators for 504 meetings, IEP meetings, and you can imagine all the technical languages that are going on in that meeting to not know what's going on, and then a document handed to you and telling you to sign off on it. So that was something we could look at from a Title VI standpoint. Next, Title VI, Title IX, and that's dealing with discrimination on the basis of sex. Now, Title IX is a big issue we deal with a lot on the post-secondary level. There's a lot of Title IX athletics. I'm not going to bore you to death with it, but it's a big portion of trying to make sure there are comparable opportunities for both males and females in athletics. So that's a big portion of our Title IX complaints we get. We also get a lot of Title IX sexual harassment complaints. And this is basically gender-based harassment. I have done a lot of presentations dealing with sexual harassment on college campuses right now. It was actually, I think, something came out in 2009, and it was at schools in our particular region, I think 37% of females reported they had been a victim of sexual harassment at some point in their college career. So that was really, really alarming, really, really interesting. So that's a big, big area we look at right now, too. Also, discrimination on the basis of sex and academic counseling and advice. And that kind of goes back to what I said earlier, dealing with the African-American students and the white students. Are we sending girls to one particular track and sending boys to another particular track? So That's what we'll be looking at when we're looking at Title IX. Section 504 of the Rehabilitation Act and Title II. Now this is going to look at disability. A large portion, I won't even say a large portion, 75% of the complaints we receive in our office are going to be dealing with Section 504 or Title II. We deal with a lot of 504 plans, a lot of IEP issues, a lot of failure to evaluate, failure to implement. And this all kind of boils down to dealing with FAPE, free appropriation of public education, and so that's a huge, huge portion of what we get. Another big chunk of our complaints deals with college students who aren't receiving academic adjustment. The difference in, I guess, K through 12 and post-secondary, in K through 12, the district has the onus. If you notice a student you think has a particular issue, you need to evaluate that student in a timely manner. Now, when you get to college, it's totally different. The onus is going to be on the student because you're an adult now. If you have a particular disability, you need to go to the college and let them know, go through their process so that you can be registered as a student and you can receive the necessary accommodation for academic adjustments. Also, lastly, denying the benefits of a program or activity because school facilities are inaccessible. A big issue now is you'll have school districts, colleges, and universities making modifications to their campus. Now, when you make a modification to a building, you've got to make sure that modification is accessible. I actually went to a college in South Georgia, and they built this fancy, beautiful, beautiful, beautiful academic lab with computers and different things for students to use. And the only way you can get it if you went up steps, 10 steps on either side of the building. So if I'm in a wheelchair, there's actually no way I can access that building. A lot of times we see issues with playground accessibility. We'll have a playground where you go in and the whole playground is made out of mulch or sand. The ground of the playground is mulch or sand. Now, if I'm in a wheelchair, how can I access anything on the playground? I can't. Also, what kind of components are on our playground? Do we have things where I can't reach it because it's 6 feet high and kids have to climb up a ladder to get to it? Or is there something that I can ride up to and manipulate on my own? So that's a big issue we deal with, the accessibility of buildings, playgrounds, and things like that as well. Now, there's been a lot of changes to the ADA. Recently in 2009, there was basically some changes in how they determine and define disability. When we look with disabilities, and especially dealing with 504 and Title II, we're going to look at a mental impairment which substantially limits one or more major life activity. Now, they didn't give us a concrete definition of what substantially limits, so it's all going to be a case-by-case analysis. Whenever you get any question with us and you ask us a question, we're going to have to tell you it's going to be on a case-by-case analysis because we don't actually know. So for instance, you might have a student who has a peanut allergy. That's a big, big issue right now. And a lot of school districts will say, well, that peanut allergy doesn't particularly affect their ability to learn, their ability to take the lesson in, but that's not what 504 says. If it substantially limits one or more major life activity, eating, digestion, anything, then they are awarded 504 protection. So that's a big, big change. A lot of times school districts, and I don't think Gwinnett has this problem, at least I haven't seen it, but school districts have the tendency to say, well, it's not affecting them in the classroom, then it doesn't affect them, and they're not protecting them in 504, but that's actually not the case. Also, if you have a record of such impairment, so let's say a particular disability that you've had in the past is not manifested itself at this particular time. That doesn't mean you would be disabled. Under our definition of disability, you can still afford protection under 504. And then the last one, this is the one that's it can be difficult for people to understand, being regarded as having such an impairment. So let's say you don't actually have the disability, but you're regarded as having it, you can receive protection under 504. And we would look at that in the harassment, from a harassment standpoint. So say if someone was regarded as being, mentally disabled, but they actually weren't. You saying, oh, well, you're mentally disabled, and harassing that person on the basis, even though they don't have it, they don't have protection under Section 504.
Name calling too.
So name calling definitely would be an example of harassment. I mean, there's a lot of different examples, and I'm going to talk about it a little bit on the next presentation, but we're going to look at, what's the nature of the name calling? How often is the name calling occurring? Because there's a little bit of analysis before we determine if the school should, be aware that harassment is taking place. Okay, and as I stated, that was the amendment happened in 2008, but it actually were gone into law in 2009. Another thing that's different, in the past, mitigating measures were not were considered. and now they're not considered. So for instance, if you had very, very, very bad vision, in the past, if you had your glasses on, you could see fine, we wouldn't look at you as a disabled student. Now, the fact that you have those glasses, we're going to still look at you as being disabled. So the mitigating measures, the medication, those things, they're not going to take away and say this person is no longer disabled. Age Discrimination Act. Now, we get complaints about age in the K through 12 setting, but a lot of times the people filing complaints don't necessarily understand what's going on. You know, they say something like, well, my kid's the youngest in the class, so the teacher's treating them differently. That's not necessarily an age discrimination complaint. What we look for is something happening because you're a certain age and you're being discriminated. So for instance, we might get a graduate program where everyone who applies to the graduate program is 35 to 40. A 55-year-old applies to the graduate program and they're denied admission. That will be something where we look and say, okay, maybe they are being discriminated on the basis of age, and we have an analysis that we go through that's similar to the analysis for, you know, race, sex, disability, where we look at all the group and say, hey, are you being treated differently? We look at the two applications. We say, what's the difference in this person's application? And then we make a determination after we were able to weigh all the different factors. This is the one I mentioned last, the Boy Scout Acts of America. I'm not going to really go over that in depth just because we don't really ever get any cases dealing with that particularly. But if you ever had any questions, if you were leading a Boy Scout troop or a Girl Scout troop and you wanted to use a public facility, so such as a library, a school, for your meetings, you're not supposed to be discriminated against. And ideally, these were just put in place because these were considered patriotic youth groups and we wanted to promote them, you know, getting out and meeting.
Can you explain patriotic a little more? What that means? And
well, like this is a very old law, but in a sense, I guess the Boy Scouts and Girl Scouts were considered to be patriotic because they were supposed to be, I guess, furthering the mission of America when they were started. And so that's why they're called patriotic youth groups. And it really only covers, those are the only two we actually give protection to. So for instance, just a club of kids that are started, you know, any kind of group of kids wouldn't necessarily get the same protection that the actual Boy Scouts would or the Girl Scouts. So that's why they called patriotic. When they were first started, it was furthering the mission of America. Okay? If you don't let them use the particular public, you know, the public space.
If someone would determine if you're not being patriotic.
It would be, but here's the question though. It might be discrimination, but would it be something we could look at? Because patriotic isn't really a protected area. So if you could find some way to say, you know, maybe you're equating patriotic dealing with race, then we could look at it. But initially saying they're discriminating against because we're not patriotic, we couldn't look at that. That would be something we would look at. Now, as I mentioned a little bit earlier about, you know, compliance reviews, being class-wide complaints and looking at class-wide compliance problems, OCR, when we get a complaint, we have 180 days basically to from start to finish, complete that entire investigation. Now, in some cases, when they're high-profile cases or things that go up to Washington, it can take a little bit longer. I don't know if any of you are familiar with the Citadel case dealing with Title IX athletics. So the Citadel was an all-male institution, females were admitted, and when I told you earlier about we're trying to, in Title IX athletics, we want to balance the opportunities for females and males. Well, Citadel only had 50 females and 2,000 males, so it's going to be really hard to balance those two opportunities for the two groups. And that would be a particular case where that's not going to take 180 days. So that Citadel case actually started when I was in high school, and it closed recently, and I work here now, so obviously you can tell them they can go for a long, long, long period of time. Now, some of our complaint resolution tools. Early complaint resolution is something that I really, really, really like because I'm a part of that team in the office, and it's basically our mediation. A lot of the complaints we have can be solved by communication. We get a lot of situations where the parents actually never got a chance to talk to the school district, and because of that, the problem hasn't been solved. But with our early complaint resolution, we bring the parties together. We bring the parties together, usually in a room. One of our employees in the office will act as a mediator. We give the parent an opportunity to state what the issue is you're having. State what you want to see come about. Then we give the university or the district, in the case of K through 12, an opportunity to respond to what the parent's saying and see what they can do. A lot of our early complaint resolutions are successful because a lot of times the groups just want to talk. They're not really asking for too much. A lot of times it's little things. I want X, Y, Z. I want a meeting on a 504 meeting. I want an IEP meeting. I want X, Y, Z considered in this 504 plan. So it's really just a breakdown of communication. So that's why I like the early complaint resolution process. And we have an initiative to kind of increase the amount of cases that actually go through this process, because it's good. Because a lot of times when we call the district and say we're investigating you, automatically they're going to take an adversarial posture. They're going to say, well, they're thinking, what should we tell them, what should we not tell them, and it becomes, really difficult as opposed to having a conversation. So early complaint resolution, if you ever file a complaint, I think that's something you should definitely consider.
If it's not resolved, then what happens?
Well, that's another thing. So let's say if you go into the negotiations, that's a very good question. You go into mediation, and let's say you can't meet a resolution. What happens is, it will go back to investigation. So initially how it happens is you file a complaint, and you're in the investigation phase. If you agree to go to early complaint resolution, then it's kicked over to our mediation side. If mediation isn't successful, then it comes back to the investigation phase as if mediation never occurred. And it's totally confidential. The person who will be conducting your early complaint resolution will not be involved in the investigation in any form or fashion. So it'll be somebody totally different who doesn't know what's going on. And if they're unsuccessful in mediating it, then it'll go back to the original investigator. Also, when early complaint resolutions are successful, we draft what we call an early complaint resolution agreement. Now this agreement is an agreement between the parties to do X, Y, Z. At OCR, we will not monitor these agreements because these agreements between the complainant and the recipient. So basically, the two parties will be the one monitoring. Now let's say someone violated the agreement. Let's say the recipient agreed to do X, Y, Z and they didn't do it. You can file a complaint with our office at that time and we'll pick back up on the investigation. So that's how we deal with that, because a lot of times people will say, well, what if they don't do what they're supposed to do? You can still you can refile your complaint and we'll continue the investigation.
So the 180 days doesn't apply to?
Yeah, it tolls completely when it's a mediation. So in the mediation process, 180 days tolls, so it's not counting, the clock's not going at all.
Okay.
Another resolution tool we have is you'll hear 302 resolution. 302 resolutions occur a lot of times when we have school districts that recognize there's a problem. So for instance, we might get a complaint from the NAACP, and they might say that a large school district in Tennessee is disproportionately disciplining black students compared to white students. The school district pulls their data, they start looking at it and they say, okay, we have a serious problem. We recognize we have a serious problem. We give them an opportunity to go into a 302 agreement. Basically, a list of things will be set out in this 302 agreement that they need to do to remedy the problem. There'll be a time period of when they need to remedy the problem by, and they'll sign off that. Now, when we have 302 agreements, what we do is we monitor those agreements. So unlike the ECR agreements, which we don't monitor, we actually do monitor the 302 agreements. And we give them timelines, and we make sure they send us information. We'll enter monitoring reports and until they basically come about alleviating whatever the particular problem was. I particularly right now have we talked about accessibility earlier. I have a case where a school district in Tennessee had to redo all their playgrounds because none of their playgrounds were accessible for elementary students. Now it's 25 playgrounds, so this was pricey. It ended up costing $2.5 million. Right now money is tight. $2.5 million is a lot of money to spend just on playgrounds. And so what happens is, to help them out, I gave them 12 years to get this done because it's impossible to say, I need you to spend $2.5 million by next week to get all these playgrounds done. And what happens is I go to that school district periodically every year, I look at their progress, I go home, draft a monitoring report, and then send it to them, send it to Washington. So that's what happens when we have 302 agreements. They're voluntary resolutions, and we're going to monitor them to make sure that people are doing what they say they're going to do.
Is that something that's typically used when it's a class complaint?
It can be used. It depends on the particular situation. It's used, for instance, that accessibility case I just told you about, that's a class complaint because they were saying that all students with disabilities in wheelchairs could use the playground. So yeah, it is used in a class complaint.
And who sets up the provisions of the voluntary resolution? Is it OCR? Is it the entity that realizes that it has a
Well,
problem?
what we do is we try to work with them. So we'll initially give a set of, a set of rules or a set of guidelines or what we want them to follow. Then we'll see, we'll give them opportunity to read it over. Is this plausible? Is this something you can do in that time period? Because we don't want to come off as, we're making you do X, Y, Z, and we know you can't do it. So again, like I go back to that $2.5 million. I'm not going to tell you have to produce $2.5 million in 1 year when you've already had to lay off 1,000 teachers in the school district. So we come up with the initial draft. We send it to the district. They'll come back with some counters. If we think those counters are reasonable, then we'll decide, okay, we can go with that. If not, we might go back to our original draft of what we had. So that's how it works. It's kind of a little bit of back and forth.
So is the complainant that filed the class complaint, are they included as part of that discussion?
No, now, in a voluntary resolution agreement, no, the complainant is not
Are
included
they
in
ever
that discussion.
notified
Are you
of
thinking
what
of the
that is?
I-squared complaint?
I absolutely am.
Yeah.
That would be the
I'm wondering
one.
where the heck is that?
Okay, and I don't know about that, and if it's still open with our office, I can't talk about it.
Right,
So I don't
right.
know, I mean, if you
I'm
ever
just
heard
trying to
back-
follow find out what the processes would be and why we haven't heard. But, so I'm
When it's
trying to
finally,
figure out what
here's what I'll tell
happens
you, when
in
it's
the
finally
background.
closed, you will receive a letter, and you'll receive a letter saying the case was closed, and it makes us our letter of finding, and in that letter of finding, we'll say that the district agreed to do X, Y, Z in a resolution agreement. Now, you
So
won't be
you
part of it
you wouldn't hear anything along the way?
in the process,
So
no,
it could go
not.
on for years and we would know nothing? Is
Well, like I said, remember when I mentioned that things go to Washington, a lot of these 302 agreements are larger scale issues, and when Washington has to make a determination on it, it can go on years. That Citadel agreement, that was a 302 agreement, and it went on for years. A lot of the agreements we have, which are larger scale class-wide complaints, can go on for years. Russell and Ali just stepped down as our assistant
Yeah, I know.
secretary.
I'm not happy about it.
Yeah, she just stepped down as our assistant secretary on December 1. But one of her initiatives was Title VI and going after school districts we feel like are discriminating students on the basis of race. So anytime we get one of those type of cases that it was a district-wide case and they were looking at racial discrimination, that was going to go to Washington. So I'm just being completely honest with you. We know when we get them, and a lot of times, you know, that's why we try to push the ECR, because ECR is a possibility if the district, you know, and the parties come together, they can negotiate it. But if it's a 302 agreement, Washington is going to have to finalize that if it's a racial one right now, and that can take time.
So have you all released the guidance
The guidance, what guidance?
around the findings, what you all investigate, how you go about it, what's considered discrimination? I understand that they're supposed to be writing it again, that is.
Well, they're updating policy guidance. They do
Right.
it every year. They pick something particularly
Well,
to
we're gonna wait
update.
for that.
Yeah, well, that's the thing, it can last longer because, you know, recently, the last year, the big push was Title IX and sexual harassment, because sexual
Right.
harassment on college is big. So we just put out guidance on that. And before that, we put out 504 guidance dealing with differences in 504 and IEP. So we put out guidance on a yearly basis, but it's not everything being updated on a
No,
yearly
I'm
basis.
waiting on disparate impact. That's
Okay, well,
all.
I'm gonna talk about disparate impact, but it's funny you mentioned that. Now, we're not getting a lot of policies that are on their face neutral, that are disproportionately affecting a group of people, and that's disparate impact, what she was just talking about. We're not getting a lot of that nowadays. A lot of what we're getting is different treatment. We're getting different treatment, so it's not so much a policy in place, but it's just treatment of, you know, one student versus another student, or one group of
Waiting on
students
that one
versus another
too.
student. Okay, and when it comes out, I'll sure to let you know.
I'm sorry.
Now, the most, you know, frequently used case resolution tool is the investigation. Basically, investigation starts with you file a complaint. You go in, file a complaint, you say, my son was treated differently on the basis of X, Y, Z. Now, your complaint is fielded by an investigator. That investigator is supposed to call you and set up a clarification call. We get a lot of complaints, and they range. We get some things that are, you know, clearly broken down, it's obvious the issue going on, and we get some things that is, you know, very hard to tell, you know, what the person is saying or what they're looking for. So that clarification call is a big, big thing, and that gives us an opportunity to clarify your allegations. Is it something that we can actually look at? Is it something that we can actually investigate? Now, after that clarification call is had, there's a case resolution team meeting where the investigator, the attorney, and the team leader get together and determine, can we go forward or if we can't go forward. If we can go forward, the next step in the process is we'll send out a letter of notification, and that will go to the complainant. That will tell them, we have received your complaint, we've reviewed it, and we're going to be able to investigate X, Y, Z. Now, in that letter of notification, there'll be a list of allegations, and these are the things we're going to investigate. A lot of times, we'll get parents where they'll get a letter of notification, it'll list what we said we're going to investigate, and at the end of the investigation, they'll say, well, you didn't look at X, Y, Z. That's why we send out the letter of notification, so you can know what we are actually going to investigate. Because we're not at the end of 180 days going to say, well, let's look at this as well. That's not going to be good for us, and it's not good for you as well, and it's not good for the district, because we have to give them notice of what we're going to look at the same time. So when we send out that letter of notification, the same day, the same time, we send the district out a data request letter. In this data request letter, we're requesting specific data that is related to the allegation. So let's say if we have a race complaint, we're going to send out a data request letter saying we need to receive a list of all the black students enrolled in this particular class and a list of all the white students. We want to find out all the referrals for black students, all the referrals for white students. We want to find out how many black students were referred to ISS and how many white students referred to ISS. So these data request letters are basically all the information we need to conduct a full investigation. Once we get that data request back from the district, then we're going to set up interviews. That's when we're going to go out on site. We're going to go interview teachers, principals, other students in some cases, trying to, get all the information we need to make a finding. Now, once we've done this interviewing, we've got our data, we've analyzed all the data, generally we're able to make a finding. Before we make that final decision, we're going to call the complainant back and present them with the information that we obtained. So if you've got a complaint, sometimes people will wonder, well, what did they say? In that rebuttal call, we call it, we'll give you all the information they provided us, give you an opportunity to give us any other information, because a lot of times, complainants will say, well, they're lying and it's because of X, Y, Z. And so if they say that, we got to go back and look and see what is this other information the complainant gave us? Is this valid information that we can use in the investigation? Once we finish the investigation, we'll send out what we call a letter of finding. A letter of finding is basically our final letter in the investigation, letting you know what we looked at, how we looked at it, what was said, and if we feel it rose to the level of discrimination on one of the laws that we can actually enforce. This is just a list of, the customer service standards we try to employ at the Department of Education. Now, I'm not going to lie to you, there's some people that work with us that don't necessarily always rise to these nice levels, but we try our best. we try our best. And in fairness to them, to be honest with you, a lot of the complainants sometimes make it hard to, to be courteous or to be professional sometimes. Some of the things they say. And lastly, as I stated, technical assistance, and that's what we're out here doing today. Giving presentations, giving workshops, giving consultations. Also, people don't use this enough, but